Good evening and welcome to the Holistic Business Plug Show, the show where we discuss business as it pertains to your whole self. So tonight we are diving into the fine print that could define your business's future. Yes, we are talking about the all-important world of contracts.
Hello, brilliant minds. I'm Chastity, your guide to navigating the complexities of entrepreneurship with clarity and vision.
And I am Tamika, here to empower you with the insights you need to make informed decisions that protect and propel your business.
And together, we're unwrapping the layers of that legal jargon to reveal the pearls of wisdom hidden in those agreements.
Exactly. Because understanding contracts you sign is not just about the now, it's about securing a healthy, thriving future for your business.
So get ready to take notes. It's time to plug in, review, and thrive.
So let's get started. Welcome back to the Holistic Business Plug. Tonight we are talking about contracts and not the government contracts that we discussed before, but business contracts, those that serve mutual interest with people we go into contracts with. So we're going to start out with giving you some best practices to consider when you are signing contracts. The first one is to make sure that you define clear objectives. So before drafting or signing a contract, both parties should have a clear understanding of the objectives. So what are the goals of this partnership or agreement? We want to ensure that the contract aligns with our objectives.
Right. So, I know when I draft contracts for the clients I serve, you have to make sure that you are talking to these people because sometimes their objectives are not clear. You can do your follow up email, draft your contract, send the agreement, and come back. Well, no, I actually said I wanted this, or I actually want this. And as a business owner, it's up to me to go back in and rewrite it because the objectives need to be clear because I don't want any misunderstandings about the services, that'll be provided.
Exactly. And that's where people fall short is because they don't define the objectives and the services. So when your client or someone that you are in a contract with come back and say, I didn't get what I asked for, I didn't get what I paid for, you don't have any recourse saying, no, this is what was laid out in the contract, this is what you signed, and this is what you agreed to, because we don't have clear definition of those objectives and what is expected of both parties.
Of both parties, because even being on the other side, as a client, you want to expect that everything that you are laying out in the beginning is what's happening. Another tip though, that I don't know if everybody has the funds to do this, but if you do, I would seek legal advice.
So yes, I would say even if you don't have the funds, you may know someone that's a lawyer that can look over something. Mm-hmm. It is very imperative. I know a lot of times, especially when we are in this age of, microwave and we do things quickly, we sign those, we check off that I agree to the terms and conditions without even reading it. Mm-hmm. But you definitely, if you're going into a contract, especially a business contract that has to do with your business,
right,
it can tank your business if the contract is not correct. Because right. If you don't have clear objectives, if you don't have clear guidelines in that contract, someone can sue you for breaching the contract, for not fulfilling the contract. So you want to make sure that you seek legal advice, whether it is online legal advice, whether you have an attorney on retainer, whatever the case may be. But you want to make sure that you are seeking legal advice from a skilled attorney.
Yeah, because they can help you understand the legal implications, identify potential pitfalls, and just basically let you know that the contract is legally sound and how to move forward as well.
Exactly, because sometimes we sign contracts and they're not actually legally binding because they're not written correctly.
Right.
And sometimes we're putting out contracts that are not legally binding. So when it comes down to it, where someone is saying, oh, I'm not fulfilling this contract, or I'm breaking the contract, you have no, again, recourse or grounds to stand on if you decide to take legal action against them because the contract is not written right.
Right. And you can't even bring it to court.
Exactly. So you want to make sure that you are definitely seeking some type of legal advice to make sure that you are putting out legally binding contracts that can be litigated if needed.
Another tip that we have is understanding the terms. Carefully read and understand all of those terms and conditions. And I know you heard that word before, terms and conditions, because in our apps and things that we download, streaming services, when you see that little box that says accept all terms and conditions, I usually click on that box and read through it because I want to know, what's going on. And so in business, you want to make sure that you are actually reading everything and not just signing it because, you may feel comfortable with that business owner. You need to read everything you're signing, no matter who it comes from. And don't be scared to ask for clarification because I know some of those are big words and it's like, wait a minute, what is this? What does this mean, right?
Exactly. And that's something that I think a lot of people don't do is read those terms and conditions, especially when it comes to just terms and conditions for apps or different things. Normally, I mean, all businesses have terms and conditions. Yeah. So you just normally just check off the box because you believe that they all say the same thing. But a lot of times, some of these apps are in other countries or these companies are in other countries, so they don't have the same regulations that we have. So you have to make sure that you are not, giving up body parts to use this app because you didn't read it. And then they have information in here that said, I can sell your personal information, or I can use your personal information to hack a system or something like that. You have to make sure that you are reading those things. And the same is true with business contracts, making sure that you read every single word, because one word in a contract can change the entire meaning of the sentence. Yeah. It can change the entire meaning of the clause. So you want to make sure that you are reading those, like you said, getting clarification if you don't understand what it means. Because again, one word in a legal clause can change the entire meaning of what that clause is. And that happens a lot of times is that people don't get clarification on the terms of the contract, or in businesses, when we're not using legal advice, we are creating contracts that are not legally binding. Right. So we're creating something that looks like a contract and we're making people sign it. But if it doesn't have the correct things in it, you have no recourse. You have no no option to litigate that contract because it's not even a legally binding document.
So basically, you don't have a leg to stand on.
You don't have a leg to stand on if you do not create a legal contract. Right. So, we can draw up contracts, and a lot of people, they say verbal contracts are just as admissible in court as a written contract. Look here. I used to tell my employees for anything as simple as I took a phone call. If it's not written down, it didn't happen. Now, I'm not an attorney, so I'm not
on paper. I mean, if anybody that's ever worked in corporate anything, I don't care where it was, if you don't document, it did not happen. And I mean, from any conversation, I don't care if I hung up with my co-worker, let me hang up per our conversation on the phone.
Exactly. And the thing is with, I'm sure that in some legal sense, a verbal agreement is legally binding, but then you have the thing of he said, she said.
She said, right. Who wants to battle that?
Exactly. Well, he said I was going to get this, and she said I was going to get this. If it's on paper, there's no disputing that. So you want to make sure that you have clear terms, that you understand the terms, and do not be embarrassed to ask, what does this
What is
mean?
this? Yep.
What does this entail? Make
Right.
sure that you are getting clear clarification before you sign your name to something. Because again, you may be signing away your firstborn and it may just read like, oh, your heritage and this and this, and you didn't even pay attention to it.
Attention to it. Because you're like,
So
oh,
you
I'm
want to
talking
make
about
sure
my heritage.
that you definitely are reading the terms and conditions. And I know in this world where we do everything quick, we just check off boxes and sign up for things and we don't read it. But that is a very bad practice to get into.
Right. Another tip that is to negotiate fairly. So being on both sides, whether you're a client or the vendor, whoever's doing the contract, be prepared to negotiate the terms, that are mutually beneficial to both parties. So this can include pricing, payment schedules, responsibilities, deadlines, dispute resolution
Mechanisms.
mechanisms. I know we can leave that here. We're not gonna cut that out. Dispute resolution mechanisms. Look, we are doing the podcast here, a TV show. Okay, things happen, but.
Exactly.
But I like this part though, because especially with the payment schedules, I don't know too much about negotiating the price because the price is my price. But sometimes I do negotiate payment schedules because there are a lot of tools that are here that offer different things for your clients to use that maybe they can't do it on the 5th, but you can work something out for them. They may can pay on the 10th. So negotiating fairly, to me, that's very important on both sides.
Exactly. And especially as new business owners or even people in corporate, a lot of
Mhm.
times we feel like if a job or someone makes us an offer that we
Mhm.
have to accept it, which we don't. You can
Right,
always negotiate. You can always negotiate a offer for a job. You can always negotiate with a contract. And I know we say the price is the price, and it doesn't necessarily have to mean that I want a reduction on the price, but maybe
right.
can you throw this in as well?
Hmm.
You can negotiate the terms, the conditions of the contract, and you want to make sure that you're doing that. Again, a lot of times we feel like we just have to accept what people give us, and
Right.
that is not true.
I remember I used to do that.
You can
I used to
negotiate for
do
what
that.
you want.
Like in corporate, Tamika, like you just said, when they would say, "Hey, well, this is the starting salary." When I was younger, this is the starting salary, and I just took it. Like, okay, this is what they're offering. I'm just gonna take it.
Mm-hmm.
No, we don't do that no
Oh, no, 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 no. We always negotiate, even if we end up in the same place. We
more.
put
Right,
it out there that, well, can I get an extra couple of days off a year, or can I get this? Whatever the case may be, can I leave early on Fridays? It's always a negotiation. You
right,
never take the first offer because then you seem too eager. Oh,
right,
yes, I got it. No, you always negotiate. And
right,
especially with your business, if there is something, because people don't realize whoever draws up the contract in their favor. So if
yeah,
I'm drawing up
yeah,
the contract favors me. So if
right.
my client doesn't negotiate anything, then the contract is going to favor me.
For me, right, right.
And the same as if someone gives me a contract, it's going to favor them. So I need to make sure that I'm reading it to make sure that I'm not getting the short end of the stick.
Right, to
Make
make
sure
sure
that I'm
that it's
getting
mutually beneficial.
exactly mutually beneficial, making sure that we both are benefiting from this. I'm not putting out 10 times as much work and not getting the benefit. So you want to make sure that, again, you are reading those contracts, making sure that you understand what the terms are, what's expected of you, what's expected of them. And always remember, whoever draws up the contract is the one that has the leg up because they draw the contract. There's no one going to draw up a contract that is going to favor the other person. It doesn't happen.
No, it doesn't work that way because it's their business. So they're
Exactly.
giving the terms and agreement to you to agree upon. So they just want you to agree and sign so we can move on. But I mean, a good business practice would to on the other end is to read through it, make sure that, hey, okay, you ain't leaving me out. You ain't have me looking crazy.
Right. And most contracts are drawn up for most business owners that are experienced with drawing up contracts. The contract is drawn up in preparation for negotiation, or the negotiation is done before the contract is drawn up. But making
right,
sure
yeah,
there's always room for negotiation. I guarantee you, if they offer you a job and they offer you a salary, there is room for negotiation.
Yes.
Use it.
Yes,
Take
that
advantage of
has been learned, like for real. Like everything's negotiation. And my youngest child, she needs to be a lawyer. Everything is a negotiation, according to her. But another thing another tip is to include performance metrics. So, if applicable, include key performance indicators like KPIs that will be used to evaluate the success of the agreement. So, this will provide a clear basis for assessing performance. So, this will be maybe towards like the service industry, if you're providing a service that can be measured.
Exactly. So, it would not necessarily apply to a product base unless it's a product that is promising to do something for you. Then you can measure the progress. So if you have this cream that in 2 months is supposed to, get rid of all your cellulite or whatever the case may be, then there should be some way to measure
hyperpigmentation.
Right. There should be some way to measure that. But yes, definitely in the service business, you want to make sure that when you are providing the contract, you are also providing, or if someone is providing a contract to you, that you are also indicating the terms of how are we going to measure that this is being effective.
Yes.
So I am in compliance. How do we measure that this compliance program is working? Or how do we measure that it is on track to where it's supposed to be? So those are the key performance indicators, those KPIs that you specify. And a lot of times that's not specified in the contract. So when someone is saying, well, we're not getting what we need, there's no way to prove that. Because how are you providing me with reports? Are you providing me with percentages or metrics or anything like that to say that you're not getting what you need? But that should be included in the contract on how are we going to measure the effectiveness of the service that's being provided.
Right. And as a social media manager, everything is measured. People want to know, how are they doing? So what I do, I have all of my clients enter in on a 90-day contract, because that way we have 90 days to determine if if what I'm doing, the service I'm providing, is working for you. So we'll have the dashboard, we can run reports, we can look and say, well, hey, this post didn't do too well. Maybe we need to change this. So those are the type of performance metrics that I have to use on a daily basis, because I wouldn't have a job. I wouldn't be able to help anybody if I couldn't at least measure like where you started before me to where you are now, that you had a little help.
Exactly. And people are not just going to take your word for it. Oh, you're doing great. No. You need some numbers. Again, if it's not written down, it did not happen. We need some numbers. We need some hard evidence that this is where we started. This is where we are now. We are improving. This area went down. This is, it has to be there. You have to be able to prove that you are doing what you've been asked to do.
Yes. And, this person, well, most people, they come in and they're like, yes, I want to see the pages that you've worked on. I want to, send me those Instagram handles, send me that Facebook, whatever. So, yes.
Yes, definitely. So we are going to take a quick break and we will be right back.
Are you a busy business owner with no time to promote your brand? Tired of trying to figure out what captions to write, what to post, when to post? You still haven't mastered graphics and how to use hashtags? At Chastity Does That, we will help you save time and money by doing these things for you. Allow Chastity Does That to manage your social media platforms, giving you time to grow and expand your business.
Welcome back to the Holistic Business Plug show, where we are getting down to the legal jargon and the hidden terms in these contracts. We have been giving great tips. Our last tip was about KPI and performance metrics, and now we want to talk about including termination clauses. Now, when you do that, you want to define the conditions under which the contract can be terminated by either party, and make sure that the termination clauses are fair and include notice periods. That is so important. Tamika, she is itching. Go ahead.
Yeah.
But
So
for real.
you definitely want to make sure that you include termination clauses, because if someone wants to terminate the contract, there needs to be guidelines on doing that. So you have to tell them, or they have to tell you, how much notice they need in order for the contract to be terminated. Is there a penalty for the contract to be terminated? What has to be fulfilled in order for the contract to be terminated? So you have to specify all of this in your contract. Otherwise, if you have created a contract and you have a client that has signed it, you don't have these things in place, they can just say, I don't
want to do it no
what
more.
I need. I'm terminating the contract.
I quit.
Exactly. Yeah. And then you are stuck out with nothing. So you want to make sure that you indicate if it may be 60 days. You have to give me a 60-day notice before you terminate the contract. Okay, 60-day notice, but still, if you are the business, they can give you a 60-day notice to terminate the contract. For example, if the contract is a year and they give you a 60-day notice to terminate the contract at 6 months, you have prepared for being paid for a year.
Right.
And now, if you haven't indicated that there is a penalty or there's a termination fee, then guess what? You just lost 6 months worth of work.
Right.
That you did not account for. So you want to make sure that the contract is as detailed as possible. There are termination clauses. There are guidelines on how you can terminate, what has to be done in order to terminate. If they terminate early, then of course you're not fulfilling the entire contract, but you also need to make sure, which we may talk about, your closeout process.
Right.
If there's a closeout process, how do you get released from the contract? Because you definitely don't want someone coming back saying, well, I paid them for this service and they didn't fulfill the service.
Right.
The service was supposed to be fulfilled in a year. You terminated in 6 months. You can't expect to get a year's worth of work in 6 months.
And that should be defined in their clear objectives up front.
Exactly. So definitely termination clause, how long they have to notify you, what is expected if the contract is terminated, if there are fees or penalties for the contract being terminated.
And you know, what are something also to include, like, what are some things that the client can do to cause a termination? Because, you know, the vendor may feel like, you know, this isn't a good fit. I've terminated contracts that I felt, okay, this isn't a good fit because it clearly states in my agreement, you have to turn in your graphics and pictures and stuff at a certain time on this day, because how am I going to get all of it together and you just turn it in to me like, ma'am, this ain't working, boo.
Exactly. So it has to be on both sides.
Right.
These are the terms. If you want to terminate the contract early, these are the terms that I can terminate the contract early. I work in compliance. So a reason for me to terminate a contract early is you are doing things that are illegal. I cannot work in this situation because as the compliance officer, that falls on me if you actually get audited and you're found to be doing things illegal.
They coming to get you.
Exactly. So if you are doing things negligent, illegal, things that are unethical, then on my part as the compliance officer, I can terminate that contract because I do not want to be involved in the shenanigans that you have going on.
That's right. Absolutely.
So definitely you want to make sure that you have termination clauses for both sides on who, how, and why the contract can be terminated either way. And not just that the contract can be terminated. There has to be reasons as to why the contract can be terminated. You can't just say, I don't want to do this anymore.
Yeah, I'm terminating this contract because
get somebody else to do it.
I'm done with you.
You need to have valid reasons as to why your contract can be terminated in your initial contract.
Right. Also, another tip is to specify deadlines, which, that's in your termination clause, but this is when you are doing projects and completing project milestones. This helps both parties are on the same page regarding timing and expectations. And that's so important. I mean, that is like so important because I don't want to tell someone that I could complete your project in 7 days when I know that it's going to be a 14 to 21 day project, right? So I want to tell them upfront, hey, this is a 21-day project. This is what is expected, blah, blah, blah. You don't want to waste people's time because if that's not specified verbally or in the email, in your contract, whatever, that can be a problem on both ends.
Exactly. Because they can say, you didn't have this done in 7 days, and you can say, well, I didn't promise you this in 7 days. So you need to have, I know when I sign a contract, when I start a compliance program, for example, there's a compliance plan and there's a timeline. So this should take this amount of time, 2 to 4 weeks. This should take 6 to 8 weeks, whatever the case may be, that you want to stay on that plan and that timeline. Yeah. Now, of course, when you're working with other people, you can't control how they operate. So this is the projected timeline. Right. But if, your staff or your company doesn't cooperate, then maybe this 2 to 4 weeks that we thought this was going to take may take 6 to 8 weeks. It's going to take
longer.
Exactly. And
I've had that happen, like you said, because sometimes it's not us. If we have the business owner, we've written it down in the contract, and then next thing you know, your client says, oh, I got to put this on pause. Oh, I have to wait another 2 weeks, whatever for this. Ma'am, this was supposed to take 14 days, and we're in the 30-day mark now. But sometimes that's just what it is. And as a business owner, you got to be flexible and roll with it. I mean, they're paying for a service, but I don't know.
But you can also
it's tricky. It's tricky. Yeah.
You can't let them control your time. Right. If you have a timeline of this is to be done in 3 months, this contract is for 3 months, we're not extending this out to 6 months. If we can't get this done, so in the contract, we have to specify your staff needs to be available. Like these are parts of the terms of the contract. Right. They have to be available at this time. They have to be available for this amount of time in order to get this completed. Now, if you, as the company or the client, doesn't fulfill your side by making your staff available, having them to do what they're supposed to do, then you're in breach of the contract. So when I walk away at 3 months, I didn't breach your contract. You didn't fulfill your end of the contract.
Bargain, right.
So that's why it's very important to make sure that you have those terms in place, that I'm available to meet once a week, and your staff needs to be available to do this, and they need to be available to do this, because of course, if a consultant comes in, your staff is still responsible for what they're responsible for. Right. But they still have to make time because you're paying that consultant to get something done, and you pay a consultant to get something done quickly.
Right. And I mean, didn't you have some things like that in your business where you were looking for staff to send you things, but it just wasn't timely?
Yeah. I mean, I've had that situation happen when I was in corporate America, when I was as a consultant, where there were things that needed to be done and they just weren't happening on the client's end. Right. And it delayed the contract. So when it was time to report those KPIs of this is where we are, this is the metric.
I don't have nothing.
I have it, but that's not what you want to see.
Right.
Exactly. So now it's looking like, well, I'm not getting what I wanted. well, I'm not getting what I wanted in order to fulfill your contract. So if we can't work this out, then like that's not a valid reason for you to terminate the contract because your staff did not do what they were supposed to do in order for me to move forward.
Right. That's
But
not
again,
that wouldn't be a validated reason for them to terminate.
that would be a validated reason for me to terminate
Yeah,
at
for
the end
you
of our
to.
term.
Right. On your, yeah.
Again, I have other clients, I have other things. You can't hold my contract up for 6 months and it was supposed to be a 3-month contract.
Or hold us hostage as we got big business. We have stuff to do.
Exactly.
One lady asked me, can she meet me at 7 p.m.? I said, at night?
PM? But people don't realize that, especially when you have your own business, that you have deadlines and you have things. I literally had a client last week that was supposed to meet with me at 3 o'clock. 3:10, I'm texting her and she's like, well, can't we just move it to 5? No, I'm busy at 5.
No.
What about tomorrow? I'm busy tomorrow. Your appointment was at 3 o'clock. Like, I guess, being a business
take appointment time seriously. People don't be taking that seriously. If I have an appointment at 3 o'clock, I'm going to be on the phone at 2:59 because I got something else to do.
Blacklist somebody that does not show up because I had this time scheduled for you. Somebody else could have had this time.
Yeah.
And you don't respect my time. You don't respect your time. You cannot rebook with me.
So they getting blacklisted?
Blacklisted.
They done.
And I can go in my calendar app and say that they cannot rebook again. So even if they went on my calendar app, it's not going to let them book.
Period.
Blacklisted. Period. Respect my time. Reclaiming my time.
Reclaim your time, baby.
But yes, it's the same thing in a contract. Making sure that people are respecting your time, your efforts.
That's true. You can put that in your terms and conditions. My office hours are from.
My office hours. Yes, exactly. And that's in my contracts. My office hours. This is when you can contact me.
Yep.
Don't be contacting me on no Saturday. Don't contact me before 10 a.m. These are my office hours. And if I choose to go outside of my office hours,
let me.
Right. But I'm not talking to you outside of office hours. We're not extending that boundary. But if I work outside of them, that's on me.
That's my business.
Making sure that there are clear guidelines. I've had a client that scheduled me to meet with them every day. And I was like, yeah, no, I'm not doing that.
Ma'am.
No.
What?
I work for myself. I don't work for anybody to be meeting and reporting every day.
Somebody every day. No.
So making sure that you definitely have clear terms and objectives in your contract so that there's no question of what is going to happen and what is expected to happen.
So guys, we are going to take a quick break and we'll be right back.
Are you fed up with your organization's current training methods? Are you and your employees bored with the same old tedious lectures and assignments? It's time for a change. Comply Prep offers an innovative online e-learning solution that covers every aspect of your business. With interactive lessons, learning has never been more engaging and efficient. Put an end to the frustration and welcome a new era of learning. Try Comply Prep now and feel the difference. Compliance made simple.
Welcome back. We are talking about contracts. And again, not those government contracts, but those business contracts. So we have been giving you all some great tips on how to make sure that you are setting up contracts correctly and making sure that you're getting them reviewed and reviewing them yourself. So the next thing we're going to talk about is confidentiality and non-disclosure. So these are very, very important to have in your contract to make sure that it's in a contract that you're signing. So you want to make sure that if your contract includes sensitive information, you want to make sure that there is a robust confidentiality clause and a non-disclosure. So with non-disclosure, that just basically means that we are protecting our proprietary information.
Yes.
You cannot take the information that you find out with working with me and go use it elsewhere.
Right.
And I can't do the same. I can't take your policies and go use them on another company.
Right.
Or whatever the case may be. But you want to make sure that you have those confidentiality and non-disclosure agreements in most cases, you want to sign a non-disclosure agreement once you first start talking to a potential client about your business and your services, or if you have an idea for a business, you want to have a non-disclosure agreement so they can't take that idea and run with it.
Now that's pretty interesting too, because that's why I've heard in some of the business group chatter that some people will sit and talk, have a so-called business meeting. Oh, let's chat, girl. Let's see how you doing. And then y'all are talking, sharing ideas, whatever, and then turn around and they done launched a whole self-care uh whatever, and yeah, so they took your whole idea and ran with it, and there's really nothing that you can do about it. I have another friend. She's a doctor, and she does these videos on Instagram pertaining to her field, and it's another content creator that literally steals her videos word for word, bro, word for word. And I mean, those disclosures can't, how do you even battle that?
So with a non-disclosure, the main way that they are used is if you have a business idea that has this differentiator. So I have this business idea and this is how I'm going to do it different.
Right.
And then you want to protect that before you actually start your business, or if you're talking with someone like an investor, you don't want that investor to go and say, oh, well, I can do that myself.
Oh, no. Okay, so it depends on who you're actually talking to.
Definitely.
Oh, yeah. Yes. Okay, so if you're talking to an investor, for sure, yeah, you want to do a non-disclosure of everything that you're discussing, because, yeah, they can decide they're not going to invest in it, right? And then
they're just going to do it themselves. Exactly.
Yeah, okay.
But it has to be something it has to be something that sets you apart. So it can't just be, I want to have a self-care business, and then they go start a self-care business.
No.
I mean, there's lots of self-care businesses.
Right.
There has to be, I want to start a self-care business, and we're going to do it this way that no one else is doing.
Right.
I have this idea for this invention, something that is unique to you.
Right. Got it.
And that if they started it or they did it, you would know they got that idea from me.
Right.
Basically.
Right.
So when you're talking about someone stealing someone's videos, that's more like intellectual property. Right. But it depends on what she's talking about. Because if it's not something that's unique to her, if it's just general information and it's educational information, then it's not necessarily, it's unethical.
It's unethical at the most. Yeah.
Exactly.
It's unethical.
But it's not illegal.
But not illegal, and that is so crazy. And people have no problem walking around being immoral, and
exactly.
And so they don't have no shame in their game at all.
Period. Exactly. You can't sue anyone for repurposing your content.
Right.
But you can sue someone if they steal a unique idea from you.
Right.
That's why people have trade secrets, trademarks and things like that to protect their intellectual property, to protect their secrets that they have within their business. You know, like KFC had the secret recipe or whatever it was, and that was one of their trade secrets. So if someone had used that, if the colonel had talked to someone about this secret recipe and then they went that and created this secret recipe for something else, then yes, that is an infringement on their intellectual property, their copyright. Even if they don't have a copyright, your idea is copyrighted because it's yours. Even if it's not legally
why you think Mr. Krabs never gave up their recipe? Oh, SpongeBob.
So yes, if you are talking about your ideas or things that you plan to implement in the future, you definitely want to have a non-disclosure agreement. And when you're signing contracts, you definitely want to have a confidentiality agreement, because you don't want either your client or the business to be able to use the information that they receive within the business or share the information. I mean, you don't want someone going around saying, oh, that business is about to go bankrupt, or this business is doing, things that you don't want out in the public for your business. So that confidentiality and non-disclosure protect that part of your business.
Right. The next tip that we can focus on is dispute resolution, outlining how disputes will be resolved. Options include the negotiation, mediation, arbitration, or litigation. Choose the method that suits your needs and also make sure that you include it in your contract.
Exactly. So a lot of times we don't think about the fact that the client and the business may not always agree. We may need to get mediation in order to resolve certain things. We may have to go to arbitration, making sure that we know if the business is in Louisiana and the client is in Alabama.
Yeah.
What law do we go by?
Right.
So all of that is specified in the dispute agreements. Do we go by the Louisiana law or do we go by the Alabama law? What happens if we don't agree and we need to go to arbitration? Do we go to a mediator first or do we go straight to a judge? Like what, all those things need to be specified in the contract in the beginning.
And that leads us into our next tip, which is being compliant with laws and regulations. Ensure that the contract complies with all relevant laws. Like you say, is it going to be here in Texas or is it going to be Louisiana, Alabama? Like, and what is it? And so they said to actually make sure of this for international agreements, because a lot of us in the business circle that I've seen, I mean, you're an international speaker. But we are, gaining clients internationally. So we would want to know what those laws and regulations could be overseas outside of the United States.
Exactly. Because, in the United States, different states have different laws, but we are all governed under the federal law. But when it comes to international contracts, they don't abide by the same laws we do. So, checking out those terms and conditions, especially like on those apps and things like contracts, they don't abide by the same laws that we do. So you have to make sure that your contracts are compliant with the laws and regulations for where your client is, where the business is, making sure that again, what law do you go by? Do you go by the law in your state or do you go by the law in the country that you are doing business with? And all of that may have to be negotiated. It may have to be worked out, mediated as far as how we handle the compliance and the laws and regulations. But you definitely want to make sure that that is specified in the contract, because if something happens, your client may say, no, we want to go by the European law and because it favors them.
Because it
And you want to go by the Texas law because it favors you. And if it's not specified in the contract as to which law we abide by, then now it's up to a judge or a mediator or someone that comes in to decide. And if you didn't specify that in that contract, then you basically put your business at risk to go with whatever the mediator decides.
Exactly. Another tip that coincides with that is insurance and liability. Clarify any insurance requirements and liability limitations. Both parties should understand that their respective responsibilities and potential risks before entering into the contract, and that insurance and liability should definitely be listed within the contract at the beginning.
Exactly. And that's a big thing when it comes to government contracts. They always specify how much insurance you need to have, how much liability insurance you need to have. They don't play. But a lot of times we don't do that in just business to business contracts where we are working as consultants or whatever the case may be. But that is very important, especially me in compliance. I need to make sure that my client has insurance in case they get fined. So I need to know that you have insurance in order to cover a fine. I have to make sure that I have insurance in case they get fined and they want to blame me for the fine. So you want to make sure that you definitely have that liability, that insurance in place, because again, me working as compliance, if my client gets fined, they can turn around and sue me and say, well, we got fined because you didn't do what you're supposed to do. So you want to make sure that you definitely specify those things in the contract in the beginning. I'm gonna keep saying that in the contract
in the beginning.
Yes, to make sure there are clear guidelines and clear terms of how this is going
the number one tip, define clear objectives. And we just, breaking it down to what all these objectives could possibly be pertaining to you and how you operate your business. The next tip is payment terms. Oh, yes. Oh, my God. Clearly specify payment terms, including the amount, the schedule, the method of payment, because this can prevent a lot of payment disputes. One thing for certain, and we have said it before, and I can't stress it enough, stop using Cash App, Zelle, and all of those Venmo types of digital transfers of monies. You need to have some type of POS payment system that is actually keeping track, because those CRM tools, they're great because it can schedule the payments for you. You don't have to send out invoice reminders. It automatically does it. It opens up other methods of payment, debit, credit, check, Afterpay, whichever. And you want to be clear in your payment terms in your contract, because you don't want to, especially with the late fee. I messed up on that in the beginning of my business, and I didn't have specified that after the 5th day that I'm going to incur whatever amount late fee every other day after. I was just like, oh my God, they didn't pay me yet. Now I'm stalking them. But if I would have been clear on my objectives and put that in my contract initially, I would not have had that problem. And I learned from that, because once I started putting it in them contracts, I started getting paid on time.
Exactly. So not only the payment terms, the schedule, also late fees, but also what happens if you pay me and the payment is returned. Like your bank is going to charge you a fee. Do I charge you a fee as well? Because now my payment is delayed. So what happens in all of these situations needs to be specified in the contract in the beginning. So yes, you definitely want to specify all of those things, whether or not you take a check, because you may think that they're going to pay you digitally, and they may decide payment is due on the 15th, and they may decide to mail you a check on the 15th. So now you're not getting paid until you're getting the check on the 20th,
the 20th,
and all of the, we have rental properties, so we know all the tricks about how to get around not paying that rent till the 15th.
Oh, you got them? You look.
We've seen them all with our tenants on how they skate around extending out their rental payments, where it looks like you've paid it, but things don't clear until, or whatever the case may be. But you want to make sure that you specify how you want to be paid, what schedule you want to be paid on, what happens if they pay you late, what happens if their payments are returned. Everything in that situation needs to be specified in the contract in the beginning.
Right. Under payment terms, make sure you know exactly how you want that to go for your business. Also, review and revise. Regularly review and update the contract, especially if those circumstances change or the agreement is long-term. Especially in the long-term agreement, things are going to change. Everything is not, businesses change. Y'all know that, the climate, the flexibility. But also when you are reviewing and revising, make sure that the contract remains relevant and fair for both parties. You don't want to, edit a contract just to continue to make it good for you. Like we said in the beginning, of course, if you are the one creating the contract, it'll be in your favor. But I mean, the moral thing to do is to make sure that it's mutually agreeable. Yeah, beneficial for everybody.
Exactly. And when it comes to reviewing and revising the contract, that also may come when things are delayed.
Yeah.
So you have your clear terms and you have your plan and your projected timeline, and then things are delayed. So you may have to adjust your timeline to say, okay, so this wasn't done within the time frame that it needed to be done, whether whoever's was the delay, whether it's the client or the business. But if it's the client, then okay, this was not done per our contract terms. You were supposed to provide this, and because this was not done within the contract terms, now we are not going to be able to complete the contract, or we're not going to be able to complete everything that was specified initially because of the delay. So I have had a contract that had almost a 6-month delay.
What?
It had a 3-month delay initially on getting started because things were not in place. And then with the client not making sure that things were getting done with their employees, it pushed it back another 3 months almost. So, of course, if your contract is a year and now we have a 6-month delay, you're going to get 6 months worth of work.
Right.
Especially if the 6-month delay was not on the part of the business. It was on
the business performing the service. Right.
Exactly. So now, of course, the business risks the client saying that they didn't get what they asked for. But you have to be very specific in your contract. It has to be specified in the contract in the beginning on how this will work if you do not fulfill your end of the contract.
Right. Absolutely. Another one is doing your due diligence. So conduct a thorough due diligence process on the other party, the person that you're doing business with. So check their financial stability, their reputation, their track record. Make sure that they even align with your values, your morals as a person and as a business. If it's somebody that you even want to do business with, a lot of people look good on the outside and then turn around on the inside. It ain't really that cool. So you have to make sure that before you get in contracts with people, before you even if the business doesn't require a contract, to me, you still want to make sure that you're doing your due diligence on a company regardless.
Exactly. And of course, because as entrepreneurs, we don't have to work with everyone. We should not work with everyone. We should work with those that align with our values, our mission, our morals. All money is not good money. We don't just accept money because they have it. So you want to make sure that you do your due diligence to make sure that this person and this business aligns with what your business aligns with. Because I guarantee you that if they do not, you will have more problems than you even can think of. Anytime that I have gone outside of this person doesn't really align with what I'm doing, well, not what I'm doing, but really align with my morals, or, I'm kind of hesitant about letting them into something, it's been the worst experience.
Every time.
Every single time. I've learned if they don't align,
just stop.
Don't do it.
Just don't do it.
Get somebody else to do it. I'm not accepting clients that don't align with me. I'm not accepting clients that I'm questionable about, that even if your mindset is not right. Like there are certain clients I want to work with. Yeah. They don't procrastinate. They have a good mindset. They are positive, things like that. If you are a negative person, if your mind is not right for what I'm doing, then get somebody else to do it, because it's going to be more hassle for me to work with you if we're not aligned and we're not a good fit. And I tell all of my potential clients that when we start our sales call, if I feel like we're a good fit, then I will tell you how I can help you. If not, I will tell you that we are not a good fit. And it is what it is.
It is what it is.
Because you can also decide that we're not a good fit.
Right. You have they absolutely can decide that as well. And that's okay.
Exactly. We both have that option. So I exercise my option, and I do tell people I don't think we're a good fit. Let me give you some resources to help you.
Yeah, because I ain't gonna be the one. Look, then let's roll. The next tip is documentation. So we did touch on this in the beginning, but keeping your records, all communications related to the contract. And so that's including your emails, minutes from a meeting, revisions to the contract itself, any correlation between you and that business. All of that should be well documented keep all of your records, because you never know when you may have to go back and say, I don't think this was happening. Let me go back and read, and make sure that, I'm getting the services that were promised to me, or vice versa.
Exactly. As I say all the time, if it's not documented, it didn't happen. I
Right.
am a person that keeps everything. So you can come to me 6 months and say, well, you didn't do this, and I'll send you an email and say, per our conversation, this is, it's a way to cover yourself. So
Right.
you want to make sure that you keep very clear documentation, very thorough documentation, to make sure that you have records of everything, especially when you're the business working with
Right.
a client. Well, we didn't get what we asked for. We didn't get this. You didn't respond to these emails. Here are the emails that I responded to. Here you go. I mean, you may
That's
not
what
have
I
seen my
said.
response, but I did respond. You want to make sure that you have clear records of everything and you're keeping
Right.
good documentation. And that's also going to allow them to trust you, because once
Oh
they
yeah.
know, she keeps everything.
And being transparent. Like, I mean,
Oh, she keeps everything. We're not
and
going to be able
do
to get over and say that she didn't do this and she didn't do that. She keeps everything.
no.
So it's a way to, again, be transparent in your business, but also be that force that says we do real business around here.
That's right. We don't play those kind of games.
Exactly.
Look, guys, we're going to take a quick break and we'll be right back.
Are you fed up with your organization's current training methods? Are you and your employees bored with the same old tedious lectures and assignments? It's time for a change. Comply Prep offers an innovative online e-learning solution that covers every aspect of your business. With interactive lessons, learning has never been more engaging and efficient. Put an end to the frustration and welcome a new era of learning. Try Comply Prep now and feel the difference. Compliance made simple.
Welcome back to the Holistic Business Plug, where we have been talking about these contracts, how to read them, everything to look for. One thing that we want to end it with is, after you have taken in all of these tips, review it by both parties. It's essential that both parties have the opportunity to review and make suggestions or changes to the contract, so that this promotes a fair and balanced agreement. Because, as you know, we have to read the fine print. So remember, a well-structured and clearly written contract can help prevent misunderstandings and disputes in the future. It's important that both parties are satisfied with the terms, and that the contract reflects their mutual understanding. So, consulting with legal professionals and other experts is key to achieving this goal.
Yes, definitely. So definitely take all of those tips before you sign the contracts. Do not just check off those terms and conditions. Make sure that you are reviewing them. But now we are in our one of our favorite segments, which is the what are we reading?
Yes.
So this week we are reading Permission to Offend by Rachel Luna.
Yes.
So this is a compassionate guide for living unfiltered and unafraid. Basically, giving yourself permission to offend has nothing to do with what you've done and everything to do with who you are becoming, the fully self-expressed human being that God has created you to be. To become that person, you must first learn to live in truth, faith, freedom, and abundance. So read this book, master the principles, become who you always known you were meant to be.
I cannot wait. I'm telling you, I love this. Just the title itself.
I am super excited about it. Yes.
Yeah, it really got me. So tonight, guys, as we close today's chapter on the Holistic Business Plug Show, we hope that you've discovered the monumental power of a well-reviewed contract.
Exactly. So we've navigated through the fine print and surface with knowledge that is valuable as any business asset.
I'm Chastity, and it's been a pleasure to help shed light on these binding documents that are the backbone of your business dealings.
Exactly. And I am Tamika. Remember, a contract is not just a formality, it's a framework for your future success.
So keep those magnifying glasses handy and never underestimate the importance of every clause and comma.
Because they definitely make a difference.
Thank
All right.
you.
So until next time, definitely stay informed, stay empowered, and stay plugged in to the pulse of your business health.
Thank you for tuning in, and make sure to join us on the next episode for more insights into the holistic approach to business.
And don't forget to follow us on our Facebook page and our group, The Holistic Business Plug, as well as follow us on our new YouTube channel with the same name. So goodbye for now and keep thriving.
Bye, guys.